Editi and then you may Mamunina Joe Almama Kwabadiaba Peace 104.3 FM so Sabri Oshe Obrenwa Ayanochi Apamus Meduno Ochi. Now you may be friend the platform, unim say platform, you may be the brow drada, and you queer the biabra. No more check us bona court na we na ya transi say na your mind guarantee and ya transi Mamunina Joe Emma Mosheshia Isaac Odro Patricia Sefa Fisher Elizabeth Agin Prince Bafo Asamoah Samuel Apia and Omashisha sa show ya medi ho chiame anwumre Mamunina Ajo ya frame na ya Kesseh ubetimi aframe the cardinal Mediki aboma manese ene mene George Opare Ado awaye emabunu don frefo NDC amanyuku no edimo National Youth Organizer of the NDC George Opare Ado Escobar ena mene no etranse anwumre a yetwetwe komo no efa Ghana ho ebedi komo na fa bebia esese ye de fa bia ye de ebefa ho enti oma mafidie na hai na frɛ onua na ka che ne se ebraso se ye de the platform dwumadie yi ebrewo ka che ne se na Kesseh ne abadwafo no atenase enti me the platform ebrew ene anwumre na ene no nanka me wo special edition bi wo University of Education Winneba na me wo special education bi wo hopa but eno asemo a esi nkwanhia esi wo suboy no eka UEW ya disuafo no bi ekokam nti eneno yenye UEW gidigidi bia but minim say sinyame ya adoma say ukuada o say adwada ne betrans UEW Council Chairman Winneba High Court Attorney General's advice let us say amanfo atwotro behind the scene ekeka nsam kofo ano me wo ho asem kan pa documents ni nyina nso kuta me wo ho asem kan pa UEW your mind dia entrance nhwema nipa ba ku bi emfa UEW nhye ne butom enka se me pese me sei suapon no enti finance officer say court no can say yemfo obia di brensa ama no mwati bida judgment na court no de man ne fa hin na sasa na wo attorney general advice no amoso wo de ma amo say ai munko yi finance minister die na mfa from ran monfa advice no attorney general be mo be advice or the word of mouth na ye mwati bida attorney general the word of mouth and obi fo mo de na me se minim ho time nyame ya adma se okua do senso juado metrance no mene mo bedi nkomo e de afa UEW but ene de eye Pablo mre enti mensa ne brand kra meba na mene Pablo Escobar the Great mene no atwetwe nkomo e de afa oman Ghana ho but UEW monye ready mame nyame ya adom a mene mo obika
so bring me baby Abwa Ghana na Ghana beyo eyo efe menwaro so rebe baby na Ghana beyo eyo
enti abusia maka ne sei no na ye ba be bon komo ma menkai menuanum Roma fo nyina se ye da so lentim azekoduro sei se nyese bia kai na mekai Isaac se Isaac lent ne yenwie ya ni refi to be honest with you Isaac ni refi cra say you will lent him but pa on tiasie as it could do on yet that Patricia so sa on cry de Ash Wednesday cra wanko na I lent ni bi intimpam chow menuanum Catholics nyina ya da so wom Bonaventure challenge no so e da so ho Isaac said them do book bro Bonaventure challenge to ochina ya kan ansa no ba adwuma because he share nyame ya adoma mebi saw echina ye dey saying bona mo show Escobar
Mini abema
ya shesha
yeah na dana ekoso
ani ma bibiri na ekoso se me hu say pa me no tena se bon komo say edison
almost 2 years
wow
after 2020 me said MTA
hey Pablo
yeah
boko there
nyame adom
the radio say, hey, and Isaac so baba na me say, hey, Isaac, ma Pablo wenji o. Hey, Charlie, hwani you. Then Pablo mapa, dia me no de be no. Also, my friend Pablo so baba.
You go far wenji, but ya we do.
Because me catch me hu wenji. O ta me monitor pa. Me hu wenji. Anyway, na wenji boko.
Na me adom.
Na 10 for no mo ye den.
Raging for the regional team conference. I'm saying, and then I could share honomo. Bono region team students and patrons. We in our be share honomo. As a Prof. Nano Pokwajman and a guest of honor, and a general say don't get here. Some number support here program.
Mate, I hope sir Omabruno Obwabo Manu ye. Oh,
Nyamin Chad ye guso. Say Jumani ye, but it's still work in progress. You did say, and I'm one of your fiancé, no. I maybe told you peguso. It's ye guso.
Yansha o party ankasa NDC. A free time I obey National Youth Organizer. Any anamoa one emebunu etu ahomboa ne nhyehyɛ waye ediama emebunu ene baabi a ewosisi ewosa di omanim akopem se yebeto ababium na se wa usenso foforo nso na beko ase di emebunu nanim anamoa one omabunu atu abesi sabre etesen
nana medical mamintia o mutie answer nzafi and then a dika meba or FDH meba swatch almost 2 years in member had I mean chill BBR would here, especially His Excellency former President Mahama and the leadership of the NDC era Samuel of Swamp of Ne Dunketia. And may various regional youth organizers and then may constituency youth organizers. The Domas near Juma Palmoye. In Crofobi war Edra, you're from Napo base, almost in country so mutio pa.
As I demand them, Edra, Major
Sunny Abacha in Crawford.
Major Abacha,
Chiapa, Mutio, the day name pa. Anyway, where be Sebi? As it stands now, between I can say, youth wing now being inherited in 2018. Your position youth wing no. Sabi, you're ready to recapture power for the NDC in 2024. Obia hu ekopa mbebuno ne NDC amanyoko ne ekon in the last elections, and you cannot look at the elections of 2020 no without looking at the contribution of young people. Omode omhobo afore o hwe sabi baby etutu ye mpo mbebuno ne dodo na sabi etuo eka omo na kan yesa ba ne sa, but that should tell you the commitment of Mebuno no towards the cause of the NDC. Enyama be brain na yeba yetumi aye, but it means we can say adwuma na sipeye yiguso. Now we have moved it from a non-functional youth wing in 2018 to a more vibrant, functioning youth wing. And Mijidi say in strong can say the most vibrant part of the NDC, the youth wing of the NDC. Apart from that, so share in student fronts now. In time past, now can in Podia now over 10 as a man. But then in almost all the campuses, 10 is way bigger than any other student groups on campus.
Wow.
Yes, and kudos once again to regional youth organizers, no, constituency youth organizers, no, and most importantly, the National 10 Secretariat and our regional 10 coordinators, no, and then the patrons network institutions, no, they've done a very good job. We can only thank God for Baby Ode Ababedu. I'm gonna say we need to count our blessings and name them one by one, and then give a Juma Nyame, Etmiamboya. And I remind you, this was a party that struggled to get 44% in 2016, and and in 2020, after 2 years of this current crop of executives, we managed to fight to the extent that India still are standing by in decision. We knew that election nobody got 50 plus 1. Bibine Corso, but even that notwithstanding, from 106 seats in Parliament to 137 seats, clearly something right happened with the leadership of the NDC, right from the flag bearer to the national chairman, all the way to the last executive at the branch, Obibiara Ejuma. And we can only give credit to Nyame. And I can assure Obibiara Ochie, with the team we have, with a little twerking. The GDP said in 2024, inshallah, the NDC will take over the affairs of this country. And the Ghana bedroom pempen so in a person the Ghana need not the current state of hopelessness are you woman.
Uhun is saying, sir, baby, wow, kai, wabefa, almost non-existent youth to the most vibrant youth, as you want to put it. A demonstration of faith in your leadership. And I said, DNA, some magic in the mouth.
I keep saying that leadership is a cause. What follows are the effects of it. And Kesseh, I can't take the credit alone. I got a very good team. My 2 deputies have been phenomenal. My regional youth organizers have been super effective. And I dedicated right from the word go, said we needed to work to restore the glory of the NDC back. But like I said, leadership is a cause. When the people believe in the cause, they follow it. And that is why Jidi said, they are yet me attaining, but collective efforts. And you enjoy total support from your flag bearer, President Mahama. Bibia youth wing na Bia, he's been at the center of it and he's been very pivotal. And that we cannot discount his contributions to the youth wing of the NDC. Apart from make us say a weekend in here or your friend say Winchi. Na bedi the immediate past running mates, me Prof. Nano Pukwajiman. But Bia inviting the Bia for a youth program ever since our partner's running mate on Pupunity, and she's also been very helpful. So we've enjoyed total support right from the top all the way to the last person. The regional chairman have been phenomenal. Udu region BMA there is that unity between the regional youth organizer and the regional chairman. Chairman being Tunja, the regional youth organizer. So you can see how we have performed and why we have been able to work so hard because of our unity now, a work between the leadership of the party, and the youth wing. We've never asked for anything at 10 and down. Sometimes even 11 towers. You may decide a program. You not catch them. You will get everybody rallying around to support it. And that is the kind of support we've enjoyed. We've also enjoyed total support from the national organizer, Yenra, Joshua Akamba. He's giving it all his support. Sometimes programs, there's a make or cramp. But friend, wherever he is, you stop, go in and stand in for me. So we've enjoyed total support and good partnership from the leadership. And that is how Kama and Ejina Baby Ejina.
Enti, Osha Baby NDC was here. We are that united, we are that purposeful for 2024. Even though months started more elections from wards upwards.
You see, if you be a moment, and I said, baby, a sing and a take a ma a sing, it me cut a crema cacra. Intino, they are when to enter cacra, but say, open unity of purpose that currently we have. Open party, are more united than right from the base. I singing from the same tune. I can confidently tell you that the NDC is very united and ever ready to wrestle power from the hands of this despotic, dishonest, and incompetent Nanado Mahmoud Bawumia administration. We are more than ready to take over power from them. And I can assure you that we have a united party that is united behind the NDC to make sure that you better wrestle power in 2024.
Finally, on NDC and issues are more a year. One major accusation that matters or more when you campaign say in 2016 went to me and independent collision of the election results. 2020 almost 1 month me and collecting more results. Abana to 1 month me and collecting more 2016. 1 month me and collecting more 2020. As national youth leader of your party, Sasam no no then I'm watching a free independent collision of election results.
2016 I was not there, so sure. I will not speak for 2016. But in 2020, ignorance, and we did not collate our results. From where I sit, I saw collated results. And you see, what is collation? You're picking results from polling stations. Now you're sending it to one central location. Even at the youth wings office. We had collated results. Because at each polling station, near our branch youth organizer or honorable. So each branch chief organizer was tasked to send results from his polling station to your office, not the national office, no.
Oh, the youth, no, some more,
America say it is absurd for anybody to sit anywhere. America say NDC and collating the results. And I know where this is coming from. Because the Supreme Court, we did not go to court with our results. That assertion is being made to NDC and collated results. But it is not true. We had our collated results, and your results collation, your 7 before the 8th and about 10 a.m. Before our second press conference, now General said address it. When we are addressing that press conference, the team led by Graphics, Officer Free Ankara, and Atosapon, were all at the national headquarters where our collated results are not my area. Now I cut 2 constituencies are. Not still, it was in dispute and Mbaye. And one of it was Tichiman South, and then the other one was it was either Esikado and Sechrios, one of them. So those were the only 2 results as at 10 a.m. Anopano on the 8th. So we know what our results were. The strategy at the Supreme Court, was not to go with our results. That is how come and a court crying for results and because people misunderstood why we're in courts. And rightly so. It was not for us to come and tell anybody say your strategy and they call courts in here. But we went to court with different reasons so that the electoral commissioner will give account and tell us why our assistant results right after declaring the results. Those were the issues near Pese courts and Eboy near Tiasi. That is why we didn't go, because our results, yes, we got it from the Electoral Commission's pink sheets. And so we were in court for very good reasons. But because of the mischief, NDC and collation of results, a big political party like the NDC, now collation of results are a rocket science. Even at the youth wings office, we had collated results. And we had 3 or 4 different collation centers. Around 4 a.m. at Himachino on the 8th, now systems need to bring a jammy, but even that, the National Coalition Center, they had their results coming in because they deployed 3 different strategies. USSD was being used, phone data was being used, and then there was another way of manual using. So we had 3 different steps. If in the worst case scenario, if the internet is even jammed, USSD and jamming. So we had our results coming in. So I don't know where there's a session of any and collection results, IFIBA. But anyway, let whoever is propagating it live in that world. We collated our results, we have our results, and it is there.
Okay. And clear misconception way once and for all. We say people misunderstood why our NDC moko court. Boy na yentiasi preko. Na fe ya sasem no yamanena. And 2. Do you not think say time wa moko court na ye bisa mo say okay say electoral commission no mo se de oye ne ye enye correct mo de amoye independently na way no na nkenye opportunity say ka mo de ne beba na say am pass electoral commission assessment results wa anke be hu say electoral commission we onye credible
anaya
papa
the credibility of the last elections is already in dispute, right? Say your processes, you can't declaration you cannot have more than 1 declaration. And in time past, the from Emrana Ferija Electoral Commissioner, and they say before results are declared, wherever there are grievances, Aferijan sets up a committee within that time. Now, not declare results a day after, usually a day or 2 after. Now you're resolving all the problems and challenges, so that once the declaration is made, everybody's concerns would have been taken on board. As a declaration, and that is how come Yenya time in 2008, because Obia challenges, Obia issues were brought before him. In 2016, Charlotte Osei did the same thing. Before the results were declared, Bebiana challenges were, Bebiana concerns were, Bebiana complaints were. No, everybody was given the opportunity to be heard. So once the declaration was made, you only accept the results. There were no controversies. What happened in this instance? Baby Ajin Mensa Kache in Asoba be declared results. She didn't go there. Conference center now is setting up stage say only bear results declaration. That didn't happen. Time I now in about bear declaration, that didn't happen. When Jin Mensa did her declaration, that same day, Udini Nabu Mane ebro 100%. That same day, she came back to change the results. As to why that happened, she did not find it prudent. Say, Obe catch Ghana for say, Ebia, me ye no constituency we buy, and I'm using me a mistake or no. She changed it until questions were asked subsequently, and some of the communication about better actually. Why did the NDC go to court? One, based on your results, they collated, say nobody had gotten 50+1. Two, we were asking the Supreme Court to tell Jane Mensah, and as a mama Jane Mensah, and Fradaka, no mbua kuntanchere Ghana for, non chere how come there were 4 different results declaration. The results that was declared on the 9th of December 2020 was different from the day they buy the next day, Even at the Supreme Court, data on the file and the Gazette were 2 different results. So all we're asking the Supreme Court to do is that as an administrative officer of the country, as an officer of this country, I'm no yedi to me ashaninsa. Ombra no mejina da kem no mbua konta, no country Ghana for as to why those disparities happen. Those different results now, we have 4 different results. The one that was declared immediately on the 9th of December, the one that was changed on the 10th, the one that was sent for the Gazette on the 15th, and then the one that finally made it to court. 4. It been see way in history mother. So the inconsistencies of it. And Obian himself, over percentage, you cannot get more than 100%. So we needed explanations as to why that happened. And that is all we're asking Jane to come in. Jane Mensah to come and answer. Also, the way the Supreme Court itself was positioned, and right from the word go, interrogatories are ne epesi ebisa. The court did not allow it, and the court made us rely on my word. Say, interrogatories now yesi kimpo no. Say, ma mene fro stand no for cross-examination. We could have asked them all those questions, but none of those happened. But anyway, the judges in their wisdom decided, say, this is how we're going to rule. Respectfully, we accepted their decision, but you know more in agree. Because we believe, say, fairness, and then there was a miscarriage of justice. Because if Jane Mensah had mounted a stand, a lot of things would have been exposed. And then in Yemen, Ghana, 4 different declarations nearby, Ghanaians would have gotten a better understanding as to why that happened. Many would say, hey, 2 years, almost 2 years after the elections, nobody knows why one election, you have 4 different results from one election. As Ghanaians, we are entitled to have answers. And that is what the Supreme Court denied here, because if they have allowed her mount the standard, she was the officer in charge of the elections. She was the returning officer. It's like a question, so that going forward, valuable lessons will be learned. Like repeating some mistakes. Unfortunately, that didn't happen, and that is where we are. And you see, because of the Niemani be a course in the last elections, in 2024, say polling stations on no more, it will be a total different ball game at the polling stations, because a honomo you may just say pepe you ABC or honomo and some will be a few honomo. So the vigilance now, the polling stations will be totally different, because in himself at that polling station the results should be declared. The other thing again that we are the courts over was the regional collation center. Well, it was not in the law, and also even the
which law?
The electoral the regional coalition centers were not supposed to have been part. It is alien to us. Nobody knows about regional coalitions. We are the only one returning officer. That is the Electoral Commission. So at consistently every elections, you display constituencies, and then when you have issues, you challenge it based on the constituencies. This time around, they set up regional coalition centers.
But that was published in the CI.
Was there?
In the CI,
the regional coalition centers. No, the regional coalition centers were not part. Okay. That was where we had our issues. But the regional coalition centers were not part of the law. But then the Electoral Commission set in. And moreover, even on the pink sheets, there was supposed to have been, to check double voting, the machine had to do some, maybe say, the printouts from the machine, any, what do you call it, the pink sheets now, almost fill it from those, there's supposed to have been a column. total number of people ebe voting in would have been recorded, and it would have also tallied with that of the machine. That column, the last day now, booklets about those columns were missing. And these were some of the things that affected the elections. What we could not do independently was to verify. Nipa here machine verify as to against Nipa here machine and verify and how they voted. All those informations were missing. So these were things that if Jane was allowed in the dock now and keep it a question, now you know lessons. So that going into the future, those mistakes were not repeated again. But in the wisdom of our lordships, I must say there be administrative officer why you no and so be a bisa na same ya yamba ho ban ne ho son no nkoda any ija no konokoda. So there's been no accountability to the people of this country. But that is what the Supreme Court have decided, and respectfully we accept.
Is it not also because maybe a more strategy na mo fire na amwam?
That I beg to differ. Because if not for anything, right from the word go, the resistance towards the NDC's application at the Supreme Court by the lordships, and how even ordinary interrogatories come reject say yes, Bisano. He leaves much to be desired, but that is what the law is. Litigation must come to an end. When they decide, they are the lords. Once they decide, we accept it and go home with it. But it is strange that ordinary interrogatories come bisa. You don't allow interrogatories, you don't allow cross-examination.
If you will be a OTM in on you say interrogatories, I will come once and make a minimal decrom, patch away the idea.
I say your cocota. Your file processes, in between, you will never be a file, be a information kakra, better and further particulars, answers be to in maybe a processes are filing in between the trial. So I say, and those processes, some are questions. It's before trial the crowd be fiancé proper now a clear doubts be. So I say, once you file the interrogatory, a clear doubts be into questions be answers be here on Saka, and then it helps in the adjudication of the trial and as in the processes of dispensing with justice. Unfortunately, we were not given that opportunity to ask our interrogatories, which was very, very unfortunate.
I see. Sasa on the yeah, but not me as a layman. Then I'm doing yemen say, me my ejuma, and I will say ejuma na me a huncha. Oh, I dance here. A chile some ejuma na me a huncha. For what dance here the black court one yensa. Oh, the auto say yen some mau quine. Nessa berry dance here if we me whole court war. Nessa fa question me. Sana na me meti de ekoso court na si nyina o enti na the Supreme Court na ma kwan.
But the law allows that.
Okay.
Discovery of documents. Say me no Kesseh. Now una ye adwuma Peace FM. And na asem na make an tia Peace FM. E bia na me adwuma ha na mapa mo me. But documents na me gina so they come asem no Peace FM for nche ya. Esa me apply to court na court ni sham them for documents nemra because then bit me aboy with the process of justice with the administration of justice and yet anything strange why the custodian of the pink sheets electoral commission what was in dispute pink sheets no so who is the best person to ask for pink sheets no apart from the electoral commission so there was nothing wrong with asking the electoral commission to make available the evidence or the declaration and mind you we were challenging the declaration. It's in documents being energy message so and on the 9th of January or on the 9th of December or did declare first results no documents being so no how did she arrive at that number na bro 100% no at the end of the sign no what did she rely on documents being so no we don't have access to that document into family the brand then all Kwako Gazette in his documents when Sulu Jina or the Koye Gazette now figure and science society. These were legitimate questions. And a Koye declaration, if it was just one declaration, and I can answer, we would not have had the cause to ask the questions we're asking. But because one declaration, yes, it's signed 3 times, we had every reason to ask Kesseh, changes, no even if you buy it. And it will open our WhatsApp information, so make it available to all of us. Scrutinize it, calculations, coming to the same conclusion. And I don't think we're asking for anything extraordinary. It was very fair.
But still at the Supreme Court, say last week or so, and Supreme Court, yeah, Transibium, as I AC Jina, FSA. Mrashe bedwam se chame eti akonwamu na ebia woni ho no ani wona na bedi akire no bia te ho a say abedi akire odi kan ho say de otoso mienu o ho kwan say o tena dwamu no ye kan mra hye bedwafo ho a o kan ne ho ka ho ene ye to aba nso a o to bi Supreme Court no say ane sa asem no more wasem. But before we come to the specifics of that case here, Supreme Court ruling, you know, Parliament also say from that you no eba be seen there, omajuma omaye it was saying.
But you said this is the first time in our history, you walk Parliament Juma. And from 1992, with all due respect, 1992, na NDC for another Dawson, how are Yakubu and her name said there was one other person, 2 independent people. Then the others came from other parties, NCP Niema, but there was not any strong opposition in 1992. So with all due respect to one was our time, it was a rubber stamp parliament. So that is when the saying came there, minority will have their say, majority will have their way.
Their way.
And from 1992 until 2020, that has been the trajectory of Ghana in terms of parliamentary democracy. Now, it was minority having their say, majority having their way. So our parliament had not truly stood up to be that independent. Now you expect to say parliament until 2021, when the electorates of this country decided they've had too many rubber stamp decisions, and rather for governance to be done properly, there should be checks and balances, and that's checks and balances must start from parliament. And this is the only parliament clearly you can see government or the executive is being held to account to the people of Ghana. And mind you, Nanaya, the people of Ghana, Yemfie, our house is the House of Parliament. It is only in Parliament, and I know we all voice. Asa. Because of the people who represent us. And if I'm to assess this Parliament, because of my idea, as it stands now, this is the most functional Parliament. Unfortunately, government has not gotten its way. So people on the government side will say, this Parliament has not been functional. But it's not been functional because I also have issues with the leadership on the part of government. Immediately, I'm realizing who say you don't have the control you should have. No, you learn how to build consensus, and you come being honest and forthright. The leadership of this current parliament on the side of the government, have not been very forthright and has not been very frank with the people of this country, and so they've not been able to build consensus with the minority. But in times like this, you need more of consensus building. Say, but you see, because of their posturing over the years, and because they enjoyed the total majority previously, Omorefi said they don't have that control anymore. And mind you, this time around, for the first time in our history in this country, a speaker who is not from the party of the executive president is the one who is administering the affairs of this country. So clearly, the dynamics that exist in this parliament are totally different. And I say kudos to our MPs who have stood their ground to help build our parliamentary democracy. Now let me come to second question on Supreme Court. And then the decision of whether the first and second deputy speaker are entitled to vote. Now, in law, same decision, same issues. What they call 2 judges, 4 anymore, and our judges 5 anymore. Obenya 3 saying A, now Obenya 2 saying B. That doesn't mean any of them is wrong. What it simply means is that our understanding of the law is different. And there are basic things that we all learned in law school that guides anybody who wants to get into such debates. You name the original jurisdiction.
Problem Pacho with about for the original jurisdiction of the Supreme Court, but ye didn't come here and near my banner at the Kahuni. On the Yaka Regional Coalition Center and Constituency, Nami Bizase, no CI, and now see Debbie. But Oshe CI 127. Now, regulation 38 of it, or say, appointment of a regional collation officer with the primary responsibility to collate constituencies, presidential election results at the regional level, and then send it to the chairman of the Electoral Commission at the head office in Accra. And he clearly knew.
Okay, but it was an introduction, or more or less. It has never been part of our CIs.
Yes, that is not in dispute.
Yeah.
You see, from 2020, even 2016, not a name.
We didn't have regional coalition.
But it does not also mean say mrebi ni ho na se uji this mra we ye na bebo untimi.
But that is where the problem started from, the regional coalition centers.
How was that a problem?
Because you see how the results were transmitted to the regions. So at the National Coalition Center, the job of the National Coalition Center became redundant. It became redundant because now you scrutinize the results, but the Bifi regions, you could not open it again and delve into it. And that is where we have challenges.
Okay.
Because usually at the national level, all of it is displayed. And then when there are issues, you raise it, they address it, they bring in the facts being sheets, and then everything is done. But that didn't happen in these elections. There was not even a place where you could go and complain. Say, ABR, results hereby, it differs from what we have. There was not a place like that because of what was being done at the regional level. And when we say it was alien to us, it's always been alien. It's never been part of our processes.
But it's not been bad. But in this particular election, CI na to me until you cannot say it is alien when it is boldly written in that CI.
Anyway, but that is where most of the confusion started from.
That should be a subject for another discussion.
Sure.
Now, the original jurisdiction of the Supreme Court, voting right of deputy speakers.
So the original jurisdiction of the Supreme Court to interpret the Constitution. But in himself, with interpretations, you do interpretations when there is ambiguity or there is confusion. And the Supreme Court will be called upon to come and give interpretations. And I call law school the doctrine of separation of powers. Call law school the political question doctrine. And I name things that are justiciable and things that are non-justiciable. These are basic things that a law school. So as a student of law, you are equipped with this knowledge right from the word go. It's the offer constitution. Now the constitution also tells you, and mind you, our 1992 constitution makes the constitution the supreme law of the land, what Kelsen calls the grun norm. It's every to me and constitution is in previously the 57-69 constitutions, now sovereignty was in parliament. It was not within. This time around, sovereignty resides with the people, but the constitution is the supreme document. So and I said that parliament are masters of its rules and procedures, and so you don't get the executive interfering in the affairs of parliament. Neither do you get the judiciary also interfering in parliament's affairs. Same vice versa. You don't get the parliament interfering in what the executive does. And you also don't get the Parliament of Ghana interfering in the workings of the judiciary. Until Obia when space Obia operating. You say one Justice Abdullah Akokot. For me, and this is my personal opinion, I am of the opinion that one, Parliament should have joined in the suit so that their voices would have been heard. Because now issues now delve into, it affected the domain of Parliament more than any other person. So Parliament should have joined within the suit, even as an amicus, to go and be part of it and then at least speak for themselves. Even though Justice Abdullah, the plaintiff, canvassed the position that Parliament naturally would have canvassed, I believe the second opinion from another legal perspective would have enriched the arguments that were laid, because Abdullah himself represented himself in courts. And then the position of the Attorney General was the position of government and what the NPP was seeking for in Parliament. My challenge and my difficulty is this. Article 102 on quorums forming. The language and the wording is very clear. There is no ambiguity. There is no ambiguity. Article 104 on voting of members of parliament states 1041 essay the Speaker of Parliament. Here the Speaker is mentioned specifically. The Speaker has no original or
casting
votes. No ambiguity. Offer 1043 now. Say ye to abano na se paya. It will be taken say omo ye for motion, you know. So ye for e-levy, for instance. Say ko 2 e-levy aba. Na abani na ye for e-levy. And opposition NDC for near against e-levy. Ye to na 137 na paya. The decision is that omo ye for no elusive votes, no. But the 104 now. So here the Speaker has no casting votes. Neither does he have an original vote. It didn't say second Speaker. It didn't say second Deputy Speaker. It just left it at Speaker.
The Speaker.
The Speaker.
Emphasis.
It only left it at the Speaker. So the assumption is already the emphasis say, granted, it is the main Speaker that it is referring to. Because the Constitution cannot solve all the problems. It means can't say it's not other legislative instruments like acts of parliament, like procedures of parliament, like standing orders, like EIs, like LIs, so that areas are constitutional, vague, it can come in and fill that gap. In Tuba standing orders, is it 108 or 110 or something? 109 in the standing orders, it comes to talk about the second Deputy Speaker not having an original vote when they are voting. The same constitution, Oko committees of parliament, I say the chairman of the committees do not have an original vote. Originally, Tuabana, we a chairman, and here the chairman was mentioned. We a chairman, I want to be. But say Edu say Apaya, the chairman is giving a casting vote. Or construe and now we interpreted documents. You take the whole document and interpret it. Now I've heard some arguments from some people in saying, oh, once the member of parliament who becomes the speaker, he's still a member of parliament, his vote should not be lost. Rightly so. But the same constitution tells you again, say, we are member of parliament. Now say, it should be a fan before the house for deliberations, First, you must declare your intentions. And then 2, when it is time for voting now, even though you're a member of parliament with voting rights, you abstain from the voting. And what does that tell you? What it simply tells you is that with issues of conflict, because assembly it is all in this constitution. So I don't know how the constitution deals with the issue of conflict of interest. And I've always said, this current Supreme Court, they have not done Ghana a lot of good in many instances. Because there was a question on conflict of interest. Group will be at the finance minister, Ken Ofriata, or court. On Ken Bond, Emra Franklin Templeton for bond issue be by. The question before the Supreme Court was to answer the issue of conflict of interest. If the Supreme Court have attempted to answer that question and have dealt with that matter, Mijini would have had a proper, clear understanding on issues of conflict. But the Supreme Court refused to answer that question. So that matter was thrown out of court. Oma answer question, So, over constitution, you say, oh, yeah, MP. Now say, yeah, betuaba. Now, wa abane eba betuno, a fawo, and now we interest me, I also declare we interest, no. Who declare interest in you are, won't mean to abanibi. You better to abanibi, but who want to be? Have you been denied your right as an MP to represent your people? Because the Constitution makes that provision. So that argument say, so your first Deputy Speaker, now Yamana and Tuabanibia, he's been deprived. There is a clause in the Constitution that enforces that, say, once you are in conflict, won't mean Tuabanibi. I have read the decision of Yoni Kolendi JSC from South decision, Justice Abdullahi versus Attorney General, with the issues pertaining to the Parliament of Ghana. Meaning, right from the word go, Justice Kolondi is very intelligent. So, what kind of decision it is patent there was an attempt to push away the issue of the political question doctrine by telling us in the judgment that question does not apply to Ghana. I beg to differ.
All my reasons.
And I'm saying I beg is the only reason. I beg to differ. On the opinion, but I beg to differ.
Say the opinion. It is premised on something.
Because the political question doctrine has found space in our jurisprudence.
Okay.
George Min can say it is only known in America and not in this country. And here it is not.
In fact, also British court.
And I'm going to say it has found space in our jurisprudence. And this is not the first time the issue of political question has made appearances in our courts.
Okay.
2, there was another attempt to create the impressions the independence of parliament and absolute. That is true. We all know that the independence of parliament is not absolute, but we also know under the 4th Republican Constitution, parliament is the master of its rules and procedures. And mind you, the same judgments, and you see that is where I find very contradictory. This statement that was made, I'll say, it must be emphasized, however, that the procedural and or operational rules to practicalize the protection of this constitutional right in a member presiding in the absence of a speaker and his or her duty to represent his or her constituents in the vote and decision are matters within the exclusive domain of parliament itself. See, your training this is how he came to conclude. So who says parliament does not have the power to deal with this matter the way it has to be dealt with?
But on the issue of parliament being a master of its own and that, okay, page 9 of the decision.
Yeah.
Me person me kind paragraph back up picture. I'll say, if the desperate interpretation preferred by the parties exclusively implicated the standing orders, a standing orders, I can say parliamentary master of his own, procedures and practices of parliament, without more, we would have had no difficulty in reaching the conclusion that parliament is and ought always to be the master of its procedures, orders, and practices without let or hindrance from the court. In such a case, this would have been matters that lie peculiarly within the domain of parliament and will therefore not be matters appropriate for judicial determination. This one is premised on the reliefs not just as Abdullah because senior Unicolendi Chona GSC or Troena or say Nipa na or na asem by reliefs are not open. 1 or say a declaration that upon a true and proper interpretation of Article 1043 of 1992 Constitution of the Republic of Ghana, the first and deputy speaker's casting vote is inconsistent with Articles 1043 of the Constitution of 1992 Republic of Ghana. 2, declaration that upon a true and proper interpretation of Article 102 and 1041 of the 1992 Constitution of the Republic of Ghana, a speaker or any other person presiding over parliament cannot be said to be part of the members present for the purposes of decision making. Now, in fact, now we know 8 reliefs. And to Kamba, Yonikulendi's argument is that Senke Base, Abana, Wamoko Trans, Parliament Foko Trans, 137, 138, no Ankwa. Any anka, Parliament no emblem, and no the Ankobe, or Mobet me defer the Parliament say, on fun standing orders Nanka. But to the extent that Nipano, the plaintiff, is praying and invoking the original jurisdiction of the court, or interpreting provisions of the 1992 Constitution, they cannot leave that interpretation for the Parliament of Ghana to do. What do you say to that?
Nobody's arguing on that. Mr. Tibai says that the original jurisdiction of the Supreme Court is for interpretation purposes. But when there is no ambiguity, you don't waste your time and waste the court's time.
But what kind of judgment? I'll say there is ambiguity.
Well, and I'm saying respectfully, that is his opinion. The wording in 103, 1043, I don't know where the ambiguity lies. And you see, let me read it.
Article 1043.
43.
Okay.
1043, I'll say. Where the votes on the motion are equal, it shall be taken to be lost. Where the votes on any motion are equal.
That is 1043.
Yes.
Where the votes on any motion.
Is that not what
equal.
Justice Abdullah was seeking interpretations for? Right? Where is ambiguity in this? Where the votes on any motion are equal, it shall be taken to be lost.
That's what the Constitution says.
Yes. Is there any ambiguity in this wording? Where do you say we say court now interpreted here now? The Supreme Court could have declined this invitation. And you see,
but all kind 1043.
Yo.
Supreme Court no so argument ni ya say there is a plentiful no.
Yeah.
All can nyina no. 1041 and now 102.
Okay, so 102.
1041.
So 102. A quorum of parliament, apart from the person presiding, shall be 1/3 of all the members of parliament. Where is the ambiguity here?
Okay.
And then 1041. Except as otherwise provided in this constitution, matters in parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of parliament present. Show me the ambiguity.
Me kind be was but me refer the exact paragraph and me kind. The Supreme Court justices address that issue or say it is not for nothing intina or ma quorum for parliament on two different instances.
Yes.
You understand?
I'll get into that argument too. So you go on me too.
No, so because where is the ambiguity? I don't know.
And I make sure say is it so 102 talks about the quorum in parliament. Or say a quorum of parliament, apart from the person presiding, shall be 1/3 of all members of parliament. What it simply means is that while all presiding, when the quorum is being counted, don't count. That is for 102. That is for parliament to originally start its business. There must be a quorum as on a parliament it may start.
And no, it's 1/3.
And no, 1/3. It's one presiding. And we are and you speaker. When you are constrained and interpreting documents, you take the whole document.
Yeah.
Here, speaker was not mentioned. What this tells you is that anybody can preside. If the days are in the absence of the first and second deputy speaker and the speaker, the members of parliament can appoint one of them to be member presiding. That's here. So that member who will be appointed to preside in the absence of even the speaker, can't quorum now.
That is the quorum for parliament to begin its
business.
Okay.
Okay. And then when it comes to voting, or say except as otherwise provided in this constitution, matters in parliament shall be determined by votes of the majority of members present. In fact, I've seen laws, the Assembly's law, for instance, the total number of members. In your crowd, you can't count. Also, members present in the chamber, a left-out chamber, but present and voting with at least half of all the members of parliament present. Can I say quorum to start meetings? 1/3.
1/3.
But see about 2 about on the floor of parliament, sir. Because it's an election, it's voting. We should have more than half
of the parliamentarians,
present.
Great.
More than half.
Sure, move on.
So maybe difficult in this. The wording here is clear.
Okay, let me ask you before you come to the clarity of your wedding. Parliament always say 275.
Yes.
Half of it saying.
I say more than half.
And to me, half.
So because the parliament means change pemono, about 138.
138.
Yes.
Okay. And at that point now, deputy speaker.
Yeah.
Presiding no. Deputy speaker no. Oyeding.
So this is where the argument gets interesting. Once the deputy speaker decides to preside, say a kind quorum from 102. Now deputy speaker is not considered as part of the quorum. You cannot move from 102 and come to 104 and automatically add the deputy speaker.
But Ojini say out of nothing, entering a constitution, framers of the constitution, set two different quorum and a quorum.
And I make sure say it flows from 102. Or say for business of parliament to start, you must have 1/3. 1/3 of 275 and 138. It's less than that. But say about 2 bar. But right from 102.
By the time no cry more constitution, no. Now you cry 245.
No, 245. Granted. I'm only looking at it.
Sure, I understand.
So say you bet 2 bar. At least because elections are important and can affect many more people. At that material moment, at least more than half should be present to vote. But mind you, 102 has told you, say, yeah, can't chrome now, our president don't count.
But what of 1041?
1041 is what I am reading. 1041 said, present and voting more than half. So flowing from 102, what I think, with my understanding of the law, is that because 102 takes out whoever is presiding, it is in the same vein, and a 104 doesn't factor while presiding.
And my layman's understanding is that Senka framers of constitution no per se 1041 fana holding free 1042 now they will have referred and come on 32 different Quran.
No, you see, so when you are for your interpretation, mind you, the constitution has a spirit.
Okay.
So I say, the constitution has a spirit. So you read the whole document to reach the interpretation. So over 102, 104. 1043.
And now we jump 143.
Was it
1041?
1041. You take it. Over 102. One for 1041. And then you take 1043. That says say a paya. Because mind you, it would have also considered the role of the speaker, say, or your member presiding now, the role he can also play in voting. Because mind you, the same constitution at the committee level say the chairman of the committee has no original votes.
But he has casting.
Maybe he has no original votes. Offer standing orders, so it takes away the original votes. Standing orders is it 108 or 109? It takes away the original votes for the second and first deputy speaker.
For when they are chairing
when you are chairing and you are seated in the chair as a presiding, it takes away your original votes. You know why? Because from my understanding of the law is that because you would have been in conflict if you are presiding, for you to also jump in and come and vote. For instance, see a voice voter. The speaker is supposed to listen. And mind you, parliament voting and apart from election of the speaker, it started from voice voters. If that one doesn't work out, then they go for the election and then do the secret vote to say voting by hands. No, it's mind you, say, oh, yeah, speaker. Na utijemu. Na yesu to me tuaba. Na ye voice voter. Na wakasa vote how would you decide whether the A's or the I's or whether the no's and the yes have it? How would you decide?
Okay, the Supreme Court says something in their decision. Over point 2, or say, okay, my main fact crime free. The last paragraph of point 1. I'll say that is to say that a presiding deputy speaker is entitled to be counted for the purposes of forming a quorum under Article 1041 of the 1992 Constitution. That upon this point 2, that upon a true and proper interpretation of Articles 102, 1041 of the 1992 Constitution, a deputy speaker or any other member of Parliament presiding over Parliament in the absence of the speaker can vote and take part in a decision by Parliament. That is to say that a deputy speaker or person presiding other than the speaker does not lose their right to vote when they are presiding over proceedings in Parliament. Accordingly, Order 1093 of the Standing Orders of Parliament is struck down as unconstitutional, and the same being inconsistent with the contravention of Article being inconsistent with and in contravention with Article 102 and 104 of the Constitution. In fact, before more is okay preamble no bana or say sa a Ghana ya was a Article 2 or Article 2 akache say and no nature and say yemre kunini ayewo and it's a constitution.
I made the same argument.
Yes.
Nobody is disputing.
Emre bia yebeye Ghana ha no say she kukum ehye sehwehe ehye anwanwa ene fa no ofa na ho odin fi 1992 constitution.
Nobody is disputing that either.
It is a koye mre bi say we are master of your own. Now because of that notion into no we mra na say obi be invoke original jurisdiction of the court no say umra na waye no So then na ho den no ko free constitution no aba and the constitution no nko enti entwamu a eno omo be ho adwuma eno nti na o ka kire o say o ma strike sa your friend saying order one free standing orders no because its root in the constitution cannot be guaranteed, and because it is unconstitutional according to the dictates of this constitution, no, it is declared null and void.
When they wrote this beautiful flowery language, this is how they concluded. Same judgment. It must be emphasized, however.
Then how can you point?
You're only calling the points now. I just called this one out. I say it must be emphasized, however, at the tail end of the judgments. It must be emphasized, however, that the procedural end or operational rules to practicalize the protection of this constitutional rights in a member presiding in the absence of a speaker and his or her duty to represent his or constituents in the votes and decisions are matters within the exclusive domain of Parliament itself. What's your here?
Oh, the honor watch him, you know. Or person or say.
I have voting rights now, procedures now, and no one someone or can and no one someone or can Also, it must be emphasized, however, that the procedural or operational rules to practicalize the protection of this constitutional right being voting once and all can. In a member presiding in the absence of a speaker and his or his duty to represent his constituents in the vote and decision are matters within the exclusive domain of parliaments.
Okay, my main kind be was na reconcile two near here. Oh, now you're lawyer. Me there. Pastor, me there be a quanchen you.
Oh, there be. It's a good intellectual discussion.
Quanchen lawyer. Don't I lawyer, Papa? Pastor, person me kind be free page 23 of their decisions nine here. Or say, in our view, the fact that the speaker alone is disqualified from voting in all circumstances, while members of parliament, which includes both deputy speakers, are disqualified from voting only on a contract where that member has a specific conflict of interest, lends the necessary clarity to the following two propositions. Firstly, the speaker is disqualified from voting not because he or she presides at sittings of parliament, but because the speaker is not a member of parliament, voting being a right only for members of parliament. 2, presiding at a sitting of parliament is not intended by the framers of our constitution to be disqualifying conflict of interest, and therefore a presiding deputy speaker does not forfeit his or her right to vote merely by virtue of presiding in the absence of the speaker. Furthermore, we are of the considered opinion that these voting disqualification rules highlight a crucial point. Members of parliament sit in parliament as elected representatives of their respective constituencies. Parliament operates on the standard democratic principle of equal representation, or one member, one vote, with matters decided by a majority vote. Therefore, to cause a member to forfeit their vote in parliament merely on account of having to preside over the business of the house in the speaker's absence would unfairly disenfranchise not only the presiding member, but also their constituents. Such an interpretation will likely give rise to certain perversive outcomes and or incentives. For example, it could lead to opportunistic absence by a speaker or one of the other speakers, as an absence will mean a vote loss by the presiding member when a member and their party, in particular, Article 96, blah, blah, blah. How do you reconcile this with your position?
This obiter was very unnecessary.
Why?
I'll tell you why.
Tell me.
Nanaya.
Papa.
If he acknowledges the fact that when you are in conflict because of over a contract, which may be serving your personal interest, which mean tuaba, which bigger conflict and the chance say me empire, I'm a Tehanomo. Now me decide say either the yes or the no's have it. Which conflict and associate no? It's me say hey. Now I'm first deputy speaker of parliament. I'm a near Hodachi. Now I'm first deputy speaker. Now we are putting it because in parliament the first votes are your voice votes. It is when there is misunderstanding and they're subjecting it to election. It's me say now me will vote nibi. Immediately I start shouting, can I hear myself?
Do you think the parliament here is here? Obibeji voice vote at two?
About many decisions have been passed by voice votes.
Those are not controversial votes.
And I make but you see, that is the we cannot pick and choose.
Yeah, we can in this case.
What it is today. Whether we like it or yes, the first option for voting is a voice vote. In the last 30 years, the fourth Republican Parliament, a lot of major decisions have been taken by voice votes. Voice vote is not alien to our laws. Inti no say, yeah, voice votes. Na me na me speaker na me timu no. Na me ame tiamu bi yeah. And I know, and I know. How would I hear myself? I will come back and say, the Amemekaino was the highest. There is not a bigger conflict of interest than this. But the good news is that this decision from this current Supreme Court, let this same case in the next 10, 15 years go before another Supreme Court. I can be confident in my heart, say, they will not return with this verdict. As for this verdict, I have tried to make sense of the judgment. They come to conclude, say, that protection of that voting rights, no, so that the presiding. Now, what was I represent to constituents, no, it lies within the domain of parliaments.
But
do you understand that statement?
No.
Even though they claim that they have striked or they are here and here out, no, they still acknowledge the fact that it is only in parliament that this can be cured.
Or see, regarding votes, no say, 137, echo rejected budget, no. Now 138 is also bad say, or my begia to Musasem, no. Tell me, can't paragraph or sister can no, and any pande back and go home because then the parliament nabit me. But so long as our constitution has 1021, 1041, no, it's so mobile.
Now, yo, they've dealt with all this, with all the flowery languages on Motroy, no. They come to conclude by saying, say, start to practicalize, say a bit me about real into practice, no. It lies within the domain of parliament. And no, they couldn't give consequential orders. So, mind you, the Supreme Court is clothed with authority to give orders.
But will you fight the Supreme Court when Nipa no didn't ask them coin no? Or no one can say when they relieve our OCQ or why can't constitutional provision? And if I hear relieve
no, you misunderstand me.
Okay.
I am saying that Supreme Court, the original jurisdiction is to interpret the Constitution. So if anybody comes before it with issues of the Constitution, it has every right to do what it did.
Okay.
The conclusions they arrived at is where I have a problem. Conclusions not arriving here, no, because you see, when you are interpreted document.
If your problem is the Constitution, it means that we know they will depart from a more say Parliament here, master of your own rules and think. But
the Supreme Court concludes by saying that statement they conclude by saying that.
But those making that argument, as I say, because Parliament here, master of that of its own rules, you know, none can say Supreme Court no entertaining. Sorry to grant. What can I say?
But I started by saying that if I was a judge on the Supreme Court, I would decline jurisdiction on this matter.
Even when somebody seeks clarification in Constitution,
because there is no ambiguity in the wording. So based on that, I started my argument by talking about ambiguity. Because the Constitution says, one, if there is ambiguity. Two, if you think a law contravenes the Constitution. Now, mind you, the young man who went to court, Justice Abdullah, he didn't go to court on the orders of Parliament. Parliamentary orders, they call court. He went to court seeking constitutional interpretations. So when I was expecting the Supreme Court to tell him, there is no ambiguity in this word.
Okay, who determines whether there's an ambiguity or not?
The courts have the right to determine.
So they have determined.
And I make us say, I have read, and I mean, Nanaya, 102, forming of quorum. Where is the ambiguity in it? The decision has come from the Supreme Court. But and this is the first time Supreme Court decision. Almost everybody is poking holes in it. Because that is not what the law should have been. But you see, you cannot fault a judge when he comes out with it. And same evidence, same facts. We have 5 judges. 2 will speak for, 3 will speak against. Until everybody and his understanding of the law. What I want to believe is our current Supreme Courts, their understanding of the law is what they have done. Because we've seen decisions, everyone that Tibano Supreme Court, no, we've read decisions from that bench. Decisions, we've read them. So for Yakufunum decisions, we've read them. And currently, we are reading the decisions that are coming. Now, this is about 24 pages, 25 pages. We've read 90 pages, 140 pages. Cogent arguments. We've read all. But the Supreme Court's position in the last 4 years, Assistant Bibri. But hey, who am I to say anything? Okay. That is the Supreme Court. But I can assure you, sir, most of the decisions they are turning out today, someday in the future, another bench will sit down, same issues, and they'll rule differently. Because you see, my understanding of the law and how laws are interpreted, no. Decision we have to, especially on the issue of conflict of interest. If an MP can be disenfranchised from voting because he's in conflicts, and then you tell me, say, a presiding member who sits as an umpire, who is going to decide a yes or a no vote based on the anipade team account or no to team will be.
I didn't know voice and
that is the first vote in Parliament.
But not only.
You don't move apart from election of speaker. Apart from the election of speaker, I know the right from the word go. You got to French, every other issue. Voice vote is the first instance.
But no, your first instance.
And I make catch us.
Yeah.
That is the first instance, whether we like it or yes. It is only when there is dispute over the voice vote, and I am subjecting it to other,
Professor William Bamboatin, thank you for your input over my education. Kakra said, was the first parliament started on 7 January 1993 and not 92. The Fourth Republic started in 1993. We keep saying 1992. The election was held in 1992, but the government and parliament took office in 93. There were 200 MPs in the first parliament of the Fourth Republic. It increased to 230 for the Fourth Parliament from January 2005. It got to 275 for Sixth Parliament from January 2013. Professor William Bamboatin, that's it. Now, George, this is from former parliamentarian Austin, and I tell Pablo that all members of Parliament on the government side almost always have interest of government business. If he insists on conflict of interest, no MP will have voting rights in Parliament.
This is absurd. This is proper absurdity. Or do you acquaint to the realm of
Honorable Sam IAP?
Maybe if you mean man. How do you acquaint to absurdity? All we are saying is that, sir, we are MP and they are in conflict and you cannot vote. Is it not the same constitution? We are chairman of a subcommittee. You cannot have an original vote. Is it not the same constitution? Have they been denied anything? Have they been denied representation of their constituents? So Yoni Kolendi's reasoning, JSC, the reasoning say Yamawa and Tuaba, you've been denied something. It is faulty and it is wrong. Because the same constitution takes that power away from presiding officers when they are presiding over committees. They don't have first original votes. Is that fatal? When you are in conflict, now we'll contract there, now BB will move here. Yamawa and Tuaba Nibi. Is that also fatal? So what is wrong when you are presiding? And I make say, Obitana or the can whoever you have a speaker who have said it was unnecessary.
Can I ask the honorable lawyer for me in your studio? Is it not in the constitution to help address issues which not clearly stated in the constitution? If there is an issue of confusion or ambiguity between the standing orders, where should we go for interpretation? Ask him. If the difference between debate and voting, not all parliamentarians take part in debates, but when it comes to voting, all of them vote. But Pablo, I didn't know one say, oh, time I may meet says some way I could be caught no. Now may argument here back up. Say, Osha constitution in one kasa. About speaker now or emphasis on the speaker. The speaker. Said the court ruling way on the by the church will almost say speaker no only a member of parliament. And a parliament are grown say parliamentarians need you over there. It may not be argument and say say 2 deputies number 2 abani bidia. Yemfa or more parliamentarians. No also mayor deputies no. So that who say your parliament, your speaker, ne deputies so obia eni ekwan so to aba.
So what will happen to committee chairman and so?
Say committee chairman no omo yen take right no free omo entirely.
They don't have
till original right is different from casting.
But the most important one is the original right.
Okay, but if you are acknowledge say constitution no je ne casting right to more, that is even more ambiguous than the now first which say me no ti hey na me chairman of the committee. Yes say ebia ni past 7 ye to aba moi 3 moi to aba we 3 se peha 3 se peha na me as chairman no me or casting voter me na me decide enti say why me casting na mfiri me nsam na say original vote nkwa there I still have my vote intact.
So you have so you see how interesting it is here. That is why 1043 settles this debate.
How?
1043 say votes ne paya. Se votes ne paya. It is taken that it is lost. What it means is that nobody has a casting vote there. So when you are even presiding, it takes away your power. You see,
because it is in direct reference to the speaker, who does not even have a vote.
And I may say the Constitution also acknowledges the facts. And I may say to get a good understanding of 104, 102, Eddie Kaimba and 104. 102 tells you quorums for parliamentary business to start. The 104 comes to tell you who can vote and what numbers is needed for a vote. So 102 tells you, say, it did not mention speaker, but it says presiding member or member presiding. It's not counted as part of the quorum. Then 104, a catcher say more than half present and voting. More than half present. And here, the emphasis should be on the word present. The one who presides, Yenkana as present, meboa. You're presiding at 102, no? He's not present, meboa. He's not counted as part. Here, the word here, present and voting. So if 102 doesn't regard Nipano presiding as a member to be present on the floor, but he's there, Yenkana Nkakoromwa, then kind numbers now. And I'm going to say 102 earlier than 104. Okay. So you cannot leave out 102 and not come to 104.
Okay, now you have Supreme Court in Asma Canon Tonchen. Now you have me in fee and come.
Yo.
I'm not sure you are 4 more fee when you know what you're saying.
And I mean 275.
Including the 2 deputies?
Yes.
And I count money 275.
And yeah, 275.
275?
Yeah.
Okay. And you say, Sa speaker na be de chiro di kan de otos mi no omo so ye mrahye bedwafo
ye gitum pa.
Okay, to omo kom mrahye bedwafi ho a omo ko ho sede
as members of parliament.
As members of parliament.
Yeah.
Enti so otre konwa no so a ema ne parliament ne member of parliament na oye no e free ho.
Say ye kan say constitution e kan in 102. Say member no preside ye kan kroma ye kan ne nka ho a. Does the constitution take his membership of parliament away? But 102 e catch us say ye kan kroma ye kan ne nka ho. What's here? Mind you, MP, say a chair MP 100,000. Oh, your first deputy speaker, they pay you more than 100,000. Oh, your second deputy speaker, you chair more than ordinary members of parliament.
Okay, compare speaker and the deputies no salary. Compare no compare speaker and say no the obetias here say say be fancy pay MPs 7,000. Now your my first and second deputy ABR 3,000 extra because of the extra duties they do in the obetias.
Exactly.
But me say share speaker nankasa. And then the deputies ne say more salary near the pay. I didn't try.
Because one is a speaker, one is a deputy. So they are president and vice pay They occupy different offices. Okay. But the mere fact say or share another channel. That is why 102. And I because with interpretation on who you sue a positive approach and but you can do a lot of things with it. You can even turn a man into a woman when you are given the right, because you always find expression in the law to say what you are saying. But the American say, offer 102 or say, oh kind koroma member now presiding. It didn't mention speaker. Any member who is presiding and kind of quorum no mebuana.
Which of the quorum?
Quorum to start parliamentary business.
That is different from
maybe
quorum
it is
to
not
vote.
different. Maybe it flows from 102 into 104. What does 104 says? 104 say ye kind nipana present and voting. So the question you ask here with the issue of present is why was the word present put there? Present in the sense that Nipa now presiding as speaker, is he present on the floor of parliament?
Yes, he is.
He's present.
Yeah.
So then why is he not part of the quorum when he's presiding?
Until I make a say, me the menya lawyer, but now me make a deal, did I mean who say? Senanka, framers of the constitution, per se, omujana say, quorum be a quoruma, and Komoka 1021, and Komo Hamon Sankoka 1041. No. But here, no, Omwatias, yes, say. Ye wakoroma ye de normal parliamentary business.
Yes.
But say ye take a decision a parliament take yamana join ye nyina as some members present no half more than half.
And then I ask you a very simple question.
Okay.
Maybe I will say. So the one who is presiding as speaker that day, is he present on the floor of parliament? No, he's not.
Why?
He's present. What is wrong? You're not on the floor.
Now
So is the speaker a member
part
of the floor?
Plenary.
So when the speaker sits up there, he's not on the floor.
We will not add the speaker because he is not a member of parliament.
And I make a just say 102 expressly tells you when you are presiding now, you are not part of the numbers on the floor of parliament. Right or wrong? To start any business, you are not part of it. And mind you, the same constitution they catch say if an issue conflicts you are not given the right to vote. Maybe one now. Now, oh yeah, empire. Now yeah. Now who can be? Are you not in conflict? How would you decide? Say we don't voice na heading, and as we don't heading. Are you not in conflict? Meaning these things are basic. Right? If lawyers wants to tend the law, and I mean, can capture say decision as the same issue, same facts. 5 judges. Ubenya 3 saying yes. Ubenya 2 saying no. It can go on appeal, and one of them who said no will come and join and say yes this time around.
No, but additional justices will
it
be
is
added.
how you feel at that mature moment and how you want to rule. Give the same facts, give the same evidence and facts to another bench. I can assure you, they'll return a different verdict. Clearly, they will not return the same verdict. That is how come Ishiba, almost every lawyer has a different perspective on this matter. I have listened to a lot of arguments, those for and those against. Because it's an issue of interpretation. And I'm saying, in all the Brofwa Justice Yoni Colin Detroit, he concludes by saying, for the practicalization of member of parliament presiding to be able to come and vote, that practicalization lies within the domain of parliament, that the courts cannot come and enforce.
Okay.
What's here? The all the flowery language, he comes to conclusions. It lies in the domain of parliament. So, wait there to enforce this constitutional right of voting. So, who preside now, person represent to a constituents. Now, at the same time, who vote now they preside here. A parliament in quite between a taking side decision, not the courts. It is in the same judgment. What's here? So, they needed somewhere to go and hide because they could not imagine parliament judicial notes, administrative notes, notes, chief justice issue. Imagine parliament decides some number issues notes because you know the confusion that will happen within the judiciary. Because when the chief justice makes those rules, it becomes laws. They administer courts. But the chief justice does not have the power to make laws. The power of laws. Making of laws, parliament in Kwadia. That is why I started by saying, that argument of non-political question doctrine, I found it very difficult because in jurisprudence now, there are so many instances that issue had come up. For instance, when the president decides, fire minister Bia, can you go and see the president in any court to come and tell him, Omra explaining why he fired the minister? No, because it's a political question. The courts cannot answer. So how then you tell us that this doctrine does not find space here because of the decision they wanted to come to?
The court can answer provided all reasons how the court say in the appointment of George Opariado as maybe the minister in charge of finance or economic planning. the criteria now constitution provides any Minister of Finance. So George does not meet that criteria, and because he does not meet that criteria, an appointment is null and void. You can make that.
The constitution, apart from 88 a cab attorney general, it didn't give any criteria for appointing any minister. So whoever the president wants, obviously I can find out the appointing. Yes, you just have to meet. You should be qualified to be a member of parliament. No, but the American says, sir, if you are professional, but there is nothing. Apart from attorney general, our constitution is specifically mentioning.
So on your lawyer.
No. There are no professional qualifications attached to anything. Once you are not a criminal, you are above 18 years of age, you don't have any criminal record, you are a registered voter, you can be made, and then you are not a dual citizen. You can be made minister. So I say, so that question cannot be answered. For instance, the orders of parliament. The orders of parliament. I don't know how it is going to be done. But now that they said they strike order 109.3 is out. No? Is the Chief Justice coming to parliament to come and tell them some year laws? It lies within the domain of the speaker. The judgment acknowledges it. I don't know, see the enforcement and practicalization of it, lies in the domain of parliament. So for me, this exercise is an exercise in futility. This decision cannot be enforced in parliament. Because when parliament sits...
Which decision?
This decision of, say, speaker, first deputy speaker, parliament. Nothing. But you see, nobody will do anything. But the parliamentarians themselves know, say, they are if they allow the court to dictate the pace of their work, they are finished. One day, immunity now. You know, when you speak on the floor of parliament, you enjoy some immunity.
I know.
Yes. If we are challenging the standing orders and other things, very soon, somebody will go and challenge that immunity in court. And you will get a bench that will come out and say that immunity is not absolute. What do you say? So,
but and
I make sure say you will get, so if we allow these things to continue,
but it will not lie in your mouth to say you allow or you will not.
And a day will come, we will get a judiciary, a bench that will sit and say so immunity 9% and absolute. Yet to come hand.
I don't know.
And let me see. So you see, also be able to say share. No sense you see there. So I say, it's where the air football. So we should tread cautiously, because you see, the only institution you need to be a sumu near the Abuja Ghana parliament, because
not the court.
You see, parliament is where you and I sit. Parliament is the house of you and I. The courts do not represent you and I. I say, parliament need. So as for parliament, every citizen of this country has a stake. It is the only house I have heard in the house of the people. So if we allow other institutions to interfere in the affairs of parliament, we are in a about the production. And it's a dangerous precedent that should not be countenanced and entertained. The Supreme Court should have declined jurisdiction on this matter.
Should have.
Yes, should have.
They didn't.
That is my opinion. And you see, my opinion is not the law. Their word is the law. But I respectfully disagree with the conclusions. And you see, what if it makes it difficult? And the conclusion of Justice Yoni Koleni says that to practicalize this and to be able to enforce the rights, the constitutional right that is guaranteed for you, the member of parliament, who is presiding and at the same time wants to represent a constituents, it lies solely in the domain of parliament. So that should tell you, say, they themselves acknowledge, say, this question was non-justiciable.
No, it is, but almost say, the entire monoba also obama so about the catch say particular standing order na udi jina so aka say any other member presiding only vote near ade no null and void.
So also we twem
to we twem
no problem. Let's see how it plays out.
We twem anya ono na eba be ye mra ma o e dey say who say mra ono so na wu jina aka say because of enunti first and second deputy speakers so more preside there omo ni vote wa metwem and it does not even arrive. It is dead on arrival.
Dead on arrival.
Okay, it is dead on arrival. Mampo in the first place. So it means some particular provision then ma obi adwen and say deputy speakers when presiding no any hompo into nka. Do you get it? That's what he's trying to tell you.
That's it.
Pablo, but unim Ariabakwa na all along me taka wasem from 2013 eba ne say na me hwe parliament bia one day ebeba no say MPP wa ban mu say no na nka NDC wo majority ana say NDC MPP wa ban mu no na ana NDC wa ban mu no
ana say majority dey nya yo no chinchim yes
oh jai
Techiman South ye jai no chinchim yes obi animo Techiman South follow the case in court you'll be amazed the rot that went on. Many James Sakosa. He knows that he's not supposed to be sitting in parliament. Yenya 138. Yenya even secretary also. The incidents is surrounding secretary also.
But some point to me defend more man to me and you.
Ah, but
Saudi and Padia. No, not me but honestly, Subaya sa 8th parliament we had done it, you know. Ama me my sister Madrin said you be near Bano. Onya ne simple majority no fan kon baby no onye na adwuma no ngo the time no but because you there are two critical things me asema that parliament e kan wa say nye 11 po na me problem. So what it practically meant ne say senka aban we enye siama no munya ba be kan ho e na ngo 137 plus 1 and 138 mo reject budget no enka den aban we Jesus san ko budget for fraud ba.
Yeah.
It in Kasa time na ye ma ban ni sika bi a onni no ko be na run o man no.
Oh, can constitution now. Yeah, will leeway 3 weeks of it me run. There is a way out. But this is not the first time a government has shut it down. In America, government has shut it down several times. No, but there is a way government could run without it. So I tell you, I can problem here now.
Minimum the Musuban we pa there.
Yeah, swear na MPP for Suban of the parliament.
In fact, if you want to be fair, pass the parliament all is here. Yeah, come on, my year to trust empire, Momo fan.
That is not true.
Why a train speaker kunya?
Why a tree speaker kunya?
Why a blade go down young cause?
Why a real ballot paper? You'll fear the other saying one condemn you and one. You fear Chileban have condemn. Why not read ballot paper?
Ghana has a lawyer. Yeah, man, he panels over ballot paper, a criminal offense.
Voting, destruction of electoral materials, a criminal offense.
Okay. Now, but the bloody coach will be here.
I don't hear.
I saw my MP.
This is an allegation. Be careful.
Where is statement of fact?
It is not true. It is not true. It is not true. Ah, na nipa na ye di blade channel wefa. Unwe.
And yes, first minister.
Who's the blade channel? Abba. E jo kopalo no crab blade.
Asam MP.
E bia do bi we beti bi the tree na the blade.
E nipa ko na beti bo na she ho.
But the read paper no. Yen can no answer.
Do read anye. Ensu bamboni.
Say sada no. Ye kan ho asem atwe o maso a. Me gidi se twede 2 years
Anaka do between speaker kunyan between.
No de man who.
Who's
be between speaker kunyan. No cremi hu yanka me ka man hu no.
Pablo de Escobar.
Anaya.
Well, it's been nice having you tonight. But me pese o sa petamba ho. Na yanka o man nankasa sikasem amamuo nankasa.
I don't until they invite me ever saba.
Oh, Zaba, Mpacho, me master. As a good group, but me da say you may say unya breba. I was for George Opare Ado, a National Youth Organizer NDC. Ono ena me no bo enkomo ena nwumre enti sene ayeka no. E standing na share bium e the platform you may so. Isaac Odro, Patricia Sefa Fisher, Elizabeth Ejin, Prince Bafwa Samuel Apia, omena hihye ena me di ho chiame. E frame me na na Kesseh ubetimi afreme the cardinal me de rade asomdwe eja munyina makramo
Yazi mzamenyina oya kwentu ahinze na ngwasum Yazi mzamane no mu nyipe nyina obi boko obi abo